Evo, lepo pozdravljeni na 11. in najverjetneje predzadnjem predavanju letnika predavanj o intelektualcih Inštituta za delavske študije. Danes je z nami Rade Pantić iz Fakultete za medije in komunikacije v Beogradu. Predaval bo v angleščini, ker tako zahteva avtoriteta. Naslov je pa meje intelektualnega udejstvovanja v obliki borbe za človekove pravice. Predavanje bo v angleščini, potem bomo imeli pa seveda tudi razpravo, kjer pa izbirate jezik, ki vam je najbližje oziroma je predavatelju najbližje. Lahko predajam besedo.
Thank you, Lawrence. Good night to everybody. So the topic of this series of lectures are intellectuals. So as you know, a predominant mode of political engagement of intellectuals today is the defense of human rights. So let's say it's not only today, it's probably since, I don't know, Émile Zola, I accuse, maybe even further in the past, I don't know, after the French Revolution. And what we are witnessing today is some form of skepticism towards human rights. There is a lot of criticism of human rights. And one book, which is written by my colleague from the Faculty of Media and Communication, is, let's say, immediate motivation for this lecture. And Belunovich is writing in his book that human rights became compromised during 90s. Because of appropriation, as he says, by the US military campaigns, which were waged for the defense of human rights, so-called humanitarian intervention. And because the book is written during the pandemics, we witnessed appropriation of some, let's say, progressive slogans by right-wingers and by, let's say, anti-vaxxer movement, like my body, my choice. So, but what was theoretically intriguing for me is that Belunovich is making this distinction between human rights and the ideology of human rights. So we have on one side human rights, and on the other appropriation, manipulation, or instrumentalization of human rights. So this was a kind of theoretically underdeveloped because we can ask question, what is the theoretical status of human rights? Under which concept we can subsume this the human rights? In this distinction, human rights are not ideology. It's not explicitly said that it is ideology. Or it's some kind of extra-ideological surplus. So what crossed my mind is that in early 80s, a famous French philosopher, Claude Lefort, one of instigators of so-called post-Marxism, made exactly this distinction between the human rights and ideology of human rights, but he used it to defend human rights. He made optimistic interpretation based on this distinction. And now Belunovich is using the same distinction, but he made a pessimistic conclusion. And Claude Lefort made this distinction while criticizing a famous Marxist critique of human rights from his famous text on the Jewish question. It is early Marxist text from 1844. So let's begin with quick recollection of Marxist text, and then we're going to expose Lefort's critique. Karl Marx text is critique of political emancipation. By political emancipation, Marx taught French Revolution and American Revolution. That means separation of a state from civil society and declaration of human rights. But this is, as I said, early Marx text. So in this period, Marx was still a humanist philosopher. So Marx thinks that by dividing state and civil society, and the man is divided in citizen and bourgeois. And this horizons of early Marx is man as a generic being, or man as a species being. It means the man who can develop the most of his capacities, of his full potential, but he is alienated in religion, and now he is doubly alienated, let's say, as a citizen, when he is enjoying rights of freedom and equality before the law, like all the other citizens, and like a bourgeois in the sphere of the civil society. And according to Marx, this citizen with this right is some kind of illusion. And the concrete reality is bourgeois, man in his everyday real activity, and bourgeois is the egoistic owner of private property. So Marx here is thinking political emancipation as some kind of illusionary emancipation, and the function of this emancipation is to buttress the man as a bourgeois, as an egoistic being. So the basic Marx conclusion is that political emancipation does not emancipate man as a human being, as this generic being, but it emancipates civil society from the political sphere. That means that it depolitizes economic relations. This is early Marx. He doesn't have yet concepts of mode of production and production relations of exploitation. So by depolitizing sphere of civil society, it gives freedom of the bourgeois as a property owner. So Marx's idea is that in feudalism, civil society was directly depolitized by feudal state, by monarchical power. Civil society for Marx in this period is like Hegel's civil society. It means estates, corporation, guilds, different religious confessions, and all these feudal institutions are connected by monarchic power, by system of privileges. So the state have direct control of civil society, and now when state is separated, autonomized from civil society, it gives free rein to a man as an egoistic being, as a bourgeois, as a property owner. And this is the famous Marxist dialectical inversion. He says, political emancipation was at the same time the emancipation of civil society from politics. And he goes, man was not freed from religion, he received religious freedom. He was not freed from property, he received freedom to own property. He was not freed from the egoism of business, he received freedom to engage in business. That means freedom of entrepreneurship. This is how Marx is interpreting fourth article of Declaration of the Rights of Man and of Citizen from 1789. Article goes, liberty consists of doing anything which does not harm others. Thus, the exercise of the natural rights of each man has only those borders which assure other members of the society the fruition of the same rights. And Marx has here a little bit moralistic interpretation. He says, the right of man to liberty is based not on the association of man with man, but on the separation of man from man. It is the right of this separation, the right of restricted individual withdrawn into himself. And conclusion is that the practical application of man's right to liberty is man's right to private property. So Marx is thinking here that the human rights are anchored in rights to private property. And this is exactly the point at which Claude Lefort is attacking him, is criticizing him. This is a famous text of Claude Lefort from 1980, Human Rights and Politics, and it is some kind of base for post-Marxism. Now, we can read a famous book by Chantal Mouffe and Ernesto Laclau, Hegemony and Socialist Politics, something like that, as a redressing of Claude Lefort's thesis into vocabulary of post-structuralism, which was 80s were the time when the post-structuralism, actually the Western appropriation of French, American appropriation of French post-structuralism was fashionable. So all they do is they redress the terminology. And Claude Lefort is saying here that by reducing human rights to the right to private property, Marx fell into the trap of bourgeois ideological version of rights, or he said, a bourgeois representation of human rights, or bourgeois ideology of human rights. And we go back to this same distinction. And he's saying that human rights goes beyond this bourgeois ideology, bourgeois version of human rights. And then he said that Marx didn't see that the separation of the state from society is the separation of a place of power from a place of right. And he is calling this incorporation of power and this incorporation of the right, which accompanies the disappearance of the king's body. So in the king's body, there was a joining of power and of right. And then with this incorporation, because the rights are now human rights are now external to power, and instead of the king, we have empty place of power. And he said it is very progressive because now neither one person or group of people can claim permanently this place of power for themselves. And Laclau and Mouffe only redressed it in empty place of power is empty signifier. So, and then he goes on that Marx, abstract juridical man of rights, this illusionary man, is not, according to Lefort, possessor of private property, but the possessor of indeterminable rights. And that declaration of human rights is producing the fiction of man without determination. What does it mean? it means that human rights are some kind of pre-legal rights. And because of that, he is making this distinction between human rights and legally objectified rights, that rights which are recognized in the law, so that human rights, or this awareness of rights, is condition of possibility and the point of legitimation of this new society, which he is calling democratic society. And he said that because of this awareness of rights, the rights go beyond any particular formulation which has been given to them. And this means that their formulation contains demand for the reformulation, or that acquired rights are not necessarily called upon to support new rights. And he is concluding that thus the awareness of rights and its institutionalization are ambiguously related. That means that because these human rights goes beyond the law, beyond the recognized rights, it sets some dynamics that groups who are being excluded from rights now are asking for their recognition, that rights contradicts each other, and it sets some new dynamism and a new democratic, let's say, struggle. So according to Lefort, Marx didn't see the practical political effects of rights, and this is instituting a new mode of social relations and a new mode of politics. He calls it democratic politics. And he said that Marx was fixed at this so-called negative liberties, and didn't see right of free association. And he didn't see that rights are not only formal, abstract, they're not only there to conceal a system of domination, as in early Marx, but they're now seen to embody a real struggle against oppression. And he goes on to say how this new claims on rights enable legal recognition of strikes, of trade unions, rights relative to work or social security, or he's mentioning women's rights, gay rights, and etc. So according to him, with human rights, history remains open. And what needs to be said is that that Lefort here took liberal interpretation of a Soviet social formation during the reign of Stalin. And he extended it to all real, so-called real socialist social formation, and said that you must have this separation between state and civil society. If there is if this border is not existent, then the state will devour civil society. And he said that this happened in real existing socialism, that state was totalized by one ideological program, and without human rights, people doesn't have a place to fight. To fight against oppression. It is basically, let's say, not a theoretical explanation of real socialist social formation, but he took a liberal one. And we can conclude that Lefort subsumed human rights under the philosophical categories. He didn't have a theoretical concept, but he is using this philosophical distinction between ontological domain and ontic domain. So we have here this indeterminable human rights, or as Hannah Arendt said, it is a right to have rights. These are rights which are not set in stone, set in the law. And this is a constituent principle. It is the principle of legitimation of new so-called democratic society. And we have this objectified, let's say, recognized human rights, which are ontic domain, historical domain, and it is constituted power. So his idea is this dialectic that human rights are principle of legitimation, but they go beyond recognized rights, and this enabling is this dynamics, this new democratic politics, and it keeps society from being stiffened, from being totalized by one totalitarian ideology. So human rights prevent the totalization of society by one ideology. We now want to elaborate this Lefort criticism, and let's start from his critique of Marxist theory of ideology on Jewish question. And it is true that Marx here has a theory of ideology which is based on the distinction between essence and appearance or between truth and illusion. He's saying there that human rights are some kind of illusion, and these egoistic individuals, this entrepreneurship in civil sphere is some kind of reality of truth. But Lefort here doesn't take in consideration that in his mature works, that means Capital and Grundrisse, it means the later Marx works, Marx has built a theory of ideology which goes beyond the problematics of illusion reality, as well as beyond the instrumentalist notion of ideology. Ideology like some kind of conscious manipulation, where some social group know the truth, and they are deceiving, lying, manipulating the others who are struck by ideological blindness. And so Marx made, in his mature works, new problematics. He asked new questions. And this quote from volume 1 of Marx Capital is according to Isaac Ilyich Rubin, which was Soviet economist, who was initiator of new school of reading of Capital, which is called value form analysis. According to him, this quote is some kind of exposition of Marx's new problematics. And I will read it. Marx said, political economy has indeed analyzed value and its magnitude, and has uncovered the content concealed within these forms. So we can say that this is what Marx is doing on the Jewish question. He sees the forms of freedom and equality, and behind this form is concealed content. It is the egoistic bourgeois. But now Marx has addition, and he goes on, but it has never once asked the question why this content has assumed that particular form. It is the question of necessity of some social form to assume some particular form. That is to say, why labor is expressed in value and why the measurement of labor by its duration is expressed in the magnitude of the value of the product. So we can say that this new question is why does some social content assume a certain particular ideological form? But we will not answer this particular question because it would be a long detour into Marxist theory of commodity fetishism and then of converted forms of surplus value. We will skip and go on directly at the question of so-called legal form, which is concept of Yevgeny Pashukanis, a Marxist Soviet theoretician of law. This is great Soviet theoreticians, Pashukanis and Rubin, but Stalin didn't have a sense for their geniality, so he killed them both. And in Capital and the other Marxist work, we have only certain passages which are dealing with question of legal form, so that theory is more developed in Yevgeny Pashukanis' work. And we can ask then this question which is derived from Marx's new problematics, that is question, why it is necessary for capitalist relation of production, which are at the same time social relations of exploitation, as we know according to Marx, why it is necessary for them to assume a legal form, to be transformed, to take a new form, and take the ideological appearance of free-willing contractual relations between free and equal legal persons. Why in this ideological appearance, this social relation of exploitation, social relations between working class and capitalist class, assume this form of free-willing contractual relation between free and equal legal persons. And one of the key quotes is for volume 3 of Capital, where Marx is saying that the specific economic form in which unpaid surplus labor is pumped out of direct or immediate producers determines the relationship of domination and servitude. That is specific economic form of exploitation. And he adds, on this specific economic form of exploitation, is based the entire configuration of economic community arising from the actual relations of producers, and hence also its specific political form. And you know Marx's theory of exploitation. Marx's idea is that exploitation is taking place under the ideological form which he calls wage form. So capitalists and workers assume that the wage is a remuneration for labor performed. That wage equals value of labor, but Marx said that wage is not equal to value of labor, but value of labor power. It is the value of necessity which are needed for reproduction of labor power. It's Marx's theory that the labor power, which in capitalism is becoming commodity, which can be bought on markets, that labor power has this specific capacity to produce more value than it itself costs. And according to this, we have here, let's say, work day. Let's say 8-hour work day. Today you are happy if you only work for 8 hours, but let's say it was the standard from the past. And this work day is divided by necessary labor time. That is the labor time required to reproduce the value of labor power. And this is a paid labor. That is what workers receive in the wage form. And after 4 hours, it is the surplus labor time performed by the workers beyond that which is necessary to reproduce his or her own labor power. And the capitalist is appropriating this surplus value in the form, ideological form of profit. And it is unpaid labor. And in capitalism, this necessary labor time and surplus labor time are, let's say, one chunk of time, one continuous time. But if we compare it to feudalism, in feudalism, necessary labor time and surplus labor time is separated by space and by time. If you have feudalism and you have serfs, peasants, necessary labor time for peasants is the work done on their plot of land. It's not their private ownership. There is not private ownership in feudalism, but they have a customary right for that land and for fruits of that land and fruits of their labor. And this is necessary labor time. And when they are doing surplus labor time, they are working for their lord, for feudalists, and it is the certain number in weeks, which are determined by customary rights, and it is on the plot of land which is lord's land. So we have here clear separation between necessary labor time and surplus labor time. And Marx said that in capitalism, in capitalist work day, there is no whistle to signalize to workers that after 4 hours they are quit working for themselves, and from now on they are working for capitalism. And this is a spontaneous illusion which grows out of this specific form of exploitation, and from this specificity of exploitation grows ideological form, which Marx is calling wage form. Workers and capitalists both perceive that wage is equal to value of labor. So because in capitalism, this necessary labor time and surplus labor time are not separated, we have so-called hidden transfer of surplus labor. We have, I will explain it later, a purely economic mode of exploitation. So hence, from there, the wage form. Wages are regarded as a payment for the labor performed, and in the sphere of circulation, which is the sphere of the exchange, exploitation of working class appears as an exchange of equivalence. It appears as some kind of fair exchange, equivalent of work for equivalent of wage. So let's now go back to this question, how specific economic form of exploitation determines specific political form. So in the pre-capitalist mode of production, like feudalism, the perceptible difference between necessary and surplus labor time determines the political relation of extra-economic compulsion as well as legal inequality. Because of this, in pre-capitalism, we have the social relation of vassalage, personal dependence. Because exploitation is, let's say, clearly visible, and because the peasants, the serfs, in feudalism had at their disposal all factors of production which are needed for their reproduction. They have labor, they have their labor power, they have means of production and they have land. So they can reproduce themselves by themselves autonomously. Because of this, political form of exploitation is this direct political appropriation of the surplus labor. It's extra economic political compulsion, and because of that, we don't have equality before the law. When you're reading a medieval law, you will see that there is one law for a lord and the other for a serf. But because we have a wage form as an ideological form of capitalist relation of production, because this wage form affects the hidden transfer of surplus value, so that does need a political form of personal dependence, and it doesn't need extra economic compulsion, but a form of free-willing contractual relation between legally free and equal possessors of personal property. It is only needed that you have idea of freedom to exchange and freedom of exchange, and this form of free-willing contractuals between politically and legally equal persons can effect exploitation and transfer of surplus labor. So the legal form thus enables the functioning of wage form, or as Pashukanis said, legal fetishism complements commodity fetishism, or again, this is paraphrase of Pashukanis, the juridification of human relations supplements the commodification of this relation. And this is one of those famous Marxist passages where he exposed the idea of legal form. Marx said, the sphere of circulation or commodity exchange, within whose boundaries the sale and the purchase of labor power goes on, is in fact a very Eden of the innate human rights. It is the exclusive realm of freedom, equality, property, and bantam. Freedom, because both buyers and sellers of commodity, let us say of labor power, are determined only by their own free will. It is freedom to contract. They contract as a free person who are equal before the law. Their contract is the final result in which their joint will finds a common legal expression. Equality, because each enters into relation with the other as with a simple owner of commodities. Both worker and capitalists have a legal title of property owners, and they exchange equivalent for equivalent wage forms, and property because each disposes only of what is his own, and bantam because each looks only to his own advantage. So, what is new thing in this Marx's new theory of ideology? It is true that legal form conceals relations of exploitation, but at the same time it is producing and enabling these processes. It is not like that legal form is a mere illusion, so you can strip legal form and see the reality of production relations. There is no functioning of these production relationships, of this relations of exploitation without legal form. Is conditions of possibility of functioning of production relations. And these are necessary ideological forms, necessary for social reproduction of the social formation, which is based on the separation of direct producers from the means of production and land. Because in capitalism, you have this separation of ownership of factors of production. Now, capitalist has property of means of production. A worker has capability to labor, have labor as a productive factor. Land ownership has land as a source of natural wealth, and there is this class of capitalists which are moneyed capitalists or financial capitalists who had money. And it is problem now to join together these separate factors of production, which are owned by different classes, and to start a process of production and reproduction. So in order to this social production and reproduction to work, wage form is then necessary form for the production and reproduction of society, for joining these factors of production into the unity of national economy. If I were talking in Serbian, I would say the narodna privreda. This unity of processes of production and reproduction. And Marx is here is talking about objective forms of thoughts. It is not a mere illusion. They are objective. They are necessary. They have this practical effect because they are enabling reproduction of social formation and processes for exploitation. So, and both social classes are victims of this ideological form, but it has different effects of them. What does it mean? As I said, it is not instrumentalist notion of ideology. And capitalists see themselves as free and equal. They think that exchange with working class is fair. They are under the ideology of wage form. They are thinking and they are doing their practice through these ideologies. But this same ideology, which affects both social classes, has a different effects. One social class is exploited, and the other social class is one who is doing the exploitation. Okay, that is a first correction of Claude Lefort theory. And we are now going to Lefort's distinction between legally objectified rights and human rights have this as this extra-ideological surplus. And we're gonna compare it with Louis Althusser's distinction between law and legal ideology. It is from Althusser's manuscript on the reproduction of capitalism. It is a manuscript which was published after Althusser's death. And from that manuscript, Althusser only published this short article, famous ideology and ideological state apparatuses. So this is the part of the manuscript which isn't present in this article. So according to Althusser, law is a system of codified rules which are applied in day-to-day practice. Okay, we can skip this systematicity of law and following Althusser about his thesis about formalism of law. Althusser said that law is necessary formal in that it bears not on the content of what is exchanged between legal persons, but on the form of these contracts regulating exchange, a form defined by the formal acts of legal persons who are formally free and equal before the law. And then he goes on and says, the formalism of law makes sense only to the extent that it is applied to the defined contents that are necessary absent from law itself. These contents are the relations of productions and their effects. What does it mean? law recognize category of legal person, and laws recognize personal property. But according to Louis Althusser, law does not discriminate between ownership, does not make distinction between ownership of means of production and ownership of labor power. By abstracting from this content, by equalizing them under the rubric of a personal property, law enables the functioning of social relations of exploitation by abstracting from this content. And this abstraction from all content is concrete condition for the effectivity of the law with respect to its content, the very content from which it necessarily abstracts. So it is a very good theoretical explanation that law can enable some social relations by abstracting from them. And it is the power of law, of civil law, contract law in this case. But then Althusser is adding that law cannot exist all by itself. So idea of Althusser is here that we freely submit ourselves to law. And there must be some ideology, some mechanism of ideological interpellation to make us to freely submit to the law. And this is according to this supplement to the law, which is, again, like in Lefort, condition of possibility of law, is a legal ideology. And Althusser said that legal ideology, while it does indeed take up the notions of freedom, equality, and obligation, it inscribes them outside the law. So, and thus outside the system of the rules of law and their limits, in an ideological discourse that is structured by completely different notions. Legal ideology, for its parts, utters a discourse that is apparently similar, but in fact altogether different. It says, men are free and equal by nature. Thus, in legal ideology, it is nature, not law, which founds the freedom and equality of man, not of legal person. So, legal ideology is supplement to law. It is the effect of the law, but at the same time it is condition of possibility of law and condition of possibility of free submission to a law. And Althusser said it's a legal ideology plus a little bit of a moral supplement. So it is not because of the fear of the punishment that you are submit to law, but because it is moral. So, as I said, human rights are both an effect of law and the condition of possibility of law and its practices. And we are now here adding Rastko Močnik's comments of Althusser and Lefort. And we can add now here that legal ideology is a privileged place of ideological interpellation in capitalist social formation. Every individual can recognize himself in human rights in this juridical fiction of the abstract individual. So this juridical fiction of the abstract individual is the fiction of man in general, of man who has a right to have rights. And all individuals who are ideologically identified, interpellated in capitalist social formation can be identified with this ideology, can say, I'm man and I have a right. And this is another layer, precisely by being separated, abstracted from any and all particular social systems, because this fiction of abstract individual man is man without particular content. The abstract individual function as a relay to, as the intersection of any set of them. So the institution of human rights perform its role of ideological articulation among different local systems of capitalist relation of exploitation and domination precisely because it is abstract. So according to Mochnik, legal ideology can be qualified as a dominant ideology in capitalist social formations. Let's say it's like in Lefort, it's go beyond law, but it has different function. It can join together all the other state ideological apparatuses, as Althusser is saying. It can harmonize their functioning, because according to Althusser, the dominant ideology is one which harmonizes different state apparatuses and different ideologies and ensures functioning and reproduction and capitalist relation of production. And there is a confusion in Althusser manuscript. I think because of that it wasn't published by him, because this function of dominant ideology is here taken by state ideology, legal ideology, scholastic ideology, alternatively. So he's first saying that the dominant ideology is state ideology that enables this harmony between the repressive state apparatuses and the ideological state apparatuses, as well as among different ideological state apparatuses. But already in this article, he expelled state ideology, because he doesn't have here theory. It's only intuition. He's saying that state ideology is some kind of mix of themes from different ideologies, political, moral, religious, national. And then later on, he's saying that legal ideology and scholastic ideologies means school ideology, school of ideology of educational state apparatuses have different function. Legal ideology is its dominant function is directly to ensure the functioning of capitalist relation of production, because of these privileged relations of this formalism of law who directly enables functioning of production relations, and scholastic or educational ideological state apparatuses play the dominant role in the reproduction of relations of production. But in notes on the ideological state apparatuses, that is the Althusser's answer to the critiques of article ideology and ideological state apparatuses, he comes to conclusion which is similar to Mochnik's. He's saying that political ideology is part of the dominant ideology and the full harmony with it. We find the same ideology everywhere in bourgeois ideology. The matrix of this dominant ideology is legal ideology, and he's using here term matrix. It is the form, it is not the content, it is the pattern. So dominant ideology is dominant not because of its content, but its form. It can absorb in itself different ideologies and transform them. And the fact that an ideology can be found everywhere indicates that we have to do with the dominant ideology. this ideology of the rights of man, freedom, equality, the freedom to choose one's ideas and one's representatives, and equality at the polls, has in the end produced the ideological state apparatus in which the political ideology of the rights of man has materialized and become self-evident truth. So Althusser here is saying that political ideology, bourgeois parliamentarism, is just one incarnation, one of materializations of legal ideology. Or Pashukanis has good intuition when he says, law, as it is a social relation in itself, is capable of coloring the other social relations to a greater or lesser degree, or of transmitting its form to them. So we can conclude that legal ideology, precisely by being separated, abstracted from other social spheres, function as a relay between them, so human rights can articulate their practices, their different ideologies, and their different function in the reproduction of capitalist social formation. So this is something, say, intuitively, if legal ideology overdetermines, articulates political practice according to its form, then we have in this articulation between legal ideology and political practice, we have bourgeois parliamentarism. We have practices of free political association and free voting for representatives. In economic sphere, because it is overdetermined by legal ideology, we have freedom of entrepreneurship and freedom to make business contracts and bargain over their condition. We have freedom to maximize individual utility. And in educational sphere, we have educational meritocracy. I think that legal ideology has priority over educational ideology, that it is one particular incarnation of legal ideology, of that educational practices is overdetermined by legal form. We have free entry and participation and competition in educational apparatuses. We have educational meritocracy, and in aesthetic sphere we have free expression and communication of authentic and disinterested tastes. We have judgment of taste, Kantian idea of disinterestedness of aesthetic sphere of art. And we can now elaborate this further on, again with Mochnik's theory, by theorizing legal ideology as an ideological mechanism of interpellation. Because Mochnik has his idea that this mechanism of interpellation is some kind of impossible dilemma, or that ideology, that this ideological mechanism can quote individual in itself by giving to that individual contradictory institutional requests. And this contradiction on which ideological interpellation in legal ideology, in ideology of human rights is made is a choice between freedom or security. And now we can theoretically elaborate this fourth article of Declaration of Rights of Men and Citizens, which had in early Marx's interpretation, it is too simplified. It is a little bit moralistic. So liberty consists of doing anything which does not harm others, but the exercise of the natural rights of each has only those borders which assure other members of the society the fruition of the same rights. we can say that exercise of freedom right can automatically produce a counter-argument of the right to security in the name of protecting the freedoms threatened by exercise freedom. I have a problem with freedom of smoking because by smoking, by exercising my freedom to smoke, I endanger security of others, their rights to healthy environment. And conversely, appeal to security can produce an appeal to the freedom abolished by security's restriction of freedom. Now I can say I'm not free if I can't smoke. So, as Močnik formulated, security is a condition of individual freedom, but at the same time it is a restriction of freedom, and restricting freedom means its abolition. So there is this question, interpellating question, because this is antinomy, this is impossible dilemma. This question is, does my exercise of freedom violate the freedoms of others? And then you have a right to freedom and right to security. These are equal rights. And when you are in every day, when you are in this problem with this, and this ideological solution caught you, you can freely submit yourself to the law. Go to the law, and then lawyers, judges, and seemingly neutral legal procedures will resolve this dilemma. But because the topic is intellectuals, here is a good Močnik explanation what the most of intellectuals are doing. They are exploiting this impossible dilemma to their advantage. We can say that intellectuals are like lawyers. They are living by trying to resolve this dilemma. And Močnik says, such a setting of the thesis naturally leads to bad infinity discussion about the fact that an individual cannot be free if his security is not assured. And when ensuring security, the state inevitably limits individual freedom, etc., etc. It is a vicious cycle. Proceeding from this setting, we can then search ad nauseam for the assumed appropriate relationship between individual freedom and its security limitation, which in that thought matrix are also the condition for its possibility. And then that measurement is reliably infinite. And it ensures at least the eternity of institutional knowledge and discourses that heroically take on this infinite task as their job and their reason for their existence. So we can say that the most of the intellectuals which work in the social sciences are trying to resolve this dilemma by finding some balance between both freedom of rights or trying to prioritize one or the other. And the Močnik solution is that if someone is trying to resolve this dilemma head-on, like the most of intellectuals, they get into the trap of the ideological interpellation. But if we give up solving the dilemma directly and move to the perspective of these practical effects of individual who is caught in this dilemma in his everyday life, who is not intellectual or lawyer to profit from this dilemma, then it can be concluded that the effect of this dilemma is to freely leave the decision to the legal institution and their juridical procedures. The effect is voluntary submission. And I try here to develop this, but it is again on the level of intuition. because Lovren said to me that to develop this, but I didn't have so much time. But my idea is this: the problematics of liberal social sciences are determined by this fundamental contradiction of human rights, which ensures the reproduction of educational ideological apparatuses. So we can say that this legal dilemma of human rights, is some kind of fundamental dilemma, fundamental contradiction, and it is then displaced on the dilemmas of other social scientists, and this dilemma is then in this converted form is forming problematics of these social scientists. Say that dilemmas of social sciences are displaced dilemmas of legal ideology, displaced in psychoanalytical sense, displaced and transformed. So we can maybe search this dilemma in economics by the dilemma maximizing personal utility versus maximizing total social welfare. And economics is going around this dilemma, try to somehow to join together, to balance these two things, to get them in accord. Or in sociology, it is dilemma agency versus structure. From the beginning of sociology, let's say in political science, it is this dilemma is the contradiction of the so-called social contract. And in aesthetics, it is autonomy of art versus transformation of society. According to aesthetic ideology, work of art is autonomized from ideological spheres, from politics, from anything which is pragmatics. And at the same time, art must transform society, must civilize, must educate, already in I don't know, Schiller's letters. And Marko Kerševan, the old Slovenian Althusserian, he is a sociologist of religion, put this very good in Althusserian fashion. The task of Marxism, of theory of historical materialism, is not to give different answers to the same old questions, like intellectuals do in this Močnik's elaboration, but to pose differently questions themselves, to get beyond this dilemma, and like Močnik to took the perspective of practical effects of that dilemma, or of its effects in reproduction of social formations. And okay, at the end I have one case study, because I think we now elaborate this distinction of Claude Lévi-Strauss, human rights versus ideology of human rights, and we can say that human rights are these formal ideological mechanisms of interpellation, dominant ideological mechanism, and that this beyond human rights, beyond the economic spheres, means that it has this wider function of articulating other ideologies and other spheres. But we must now address this Lefort claim that human rights means fight against oppression. And this is this legal case studies is already elaborated by Robert Knox. It is a British theoretician, British Marxist theoretician of law, and Maya Breznik is already elaborated it. And this is a legal case in which National Union of Rail, Maritime and Transport Workers, RMT, brought a claim against the UK to the European Court of Human Rights, concerning the right to engage in secondary and sympathy strike action. Secondary and sympathy strike action is strike of solidarity. You work in one factory and there is strike in another factory, so you go in a strike to help the cause of the other workers. It means uniting working class in struggle across the companies, across productive units, and these strikes of solidarity or secondary strikes are explicitly banned in UK, in British state, and they are banned in 1980 by the government of Margaret Thatcher as a part of neoliberal reforms that wanted to destroy class solidarity of the working class, to fragment working class. And the case is this. 20 RMT members of this syndicate, worked for a company, Jervis, and then they were moved to the company Hydrex. But they kept terms and conditions of their original contracts, and these were at a significantly higher levels than the other workers in Hydrex. Then, a couple of years later, Hydrex management sought to reduce the wages of these 20 employees, and these members of RMT, these employees, voted in favor of a strike. But this strike action ultimately proved ineffective due to the small number of unionized workers in Hydrex. Then the RMT argued that if Jarvis workers had been able to go on strike in sympathy of solidarity with the Hydrex workers, the strike action would have proved more effective. If the workers from this company Jarvis, we had more unionized workers joined in strike with Hydrex, then this action can be more effective. Okay, I'm gonna skip this. So the RMT argued that this was a breach of Article 11 of European Convention of Human Rights. It is breach of freedom of assembly and association. And it sued British state because by banning explicitly strikes of solidarity, they breached the freedom of assembly and association. But when we read this article, we can find in it the same impossible ideological dilemma. So everyone, according to paragraph 1, has the right to freedom of peaceful assembly and to freedom of association with others, including the right to form and join trade unions for the protection of his interests. So trade unions are enumerated explicitly, but they have now side of the security. No restrictions shall be placed on the exercise of these rights other than such as are prescribed by the law and are necessary in democratic society. What does it mean? It is precisely some indeterminacy which enables interpretation of law. It doesn't say anything explicitly. It can mean different things. Or in the interest of national security or public safety. It is, again, indeterminable. It can be interpreted in various ways. For the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedom of the others. So the legal dispute concerned the interpretation of this article, that is, crass struggle was waged over the interpretation of an impossible dilemma. So whole class struggle is by this abstracting function of legal ideology and the law is narrowed in this one question. And okay, there were previous cases when court decided in the favor of trade unions. In this one, court ruled that the words for the protection of his interests implied a wider set of rights than simply joining a trade union. This meant that a trade union must thus be free to strive for the protection of its members' interests. Although the court denied a right to collective bargaining, it must be possible for trade union to take steps, including organizing industrial action with a view to persuading the employer to enter into collective bargaining. That strikes are not explicitly legalized. But if you can prove that strike is done with a view to persuade the employer to enter into collective bargaining, then it can be under the legal protection. It means that workers which took part in strike cannot be dismissed, fired, and that people who organize that strike, that leaders of trade unions, cannot be persecuted by the law. And then in the other case, court even went further, and starting that the right to bargain collectively with the employer has in the principle become essential elements of Article 11. So RMT claim was based in that the ban on secondary action prevented the RMT from being able to pursue its members' interests and was an infringement of the ability to engage in collective bargaining. So class struggle must be formulated in the legal terms. And UK claimed that secondary action is not an essential element of this article. And furthermore, they argued that whilst Article 11 allows for a right to strike, this can be restricted according to paragraph 2. They argued that secondary action could impinge, can violate the rights of the individuals not party to the dispute, security of others, and could imperil economic recovery. So economic recovery is some kind of national security issue. In the later case, the government also argued that the restrictions had come about because of disruptive effects of the secondary strike in the 70s, in the era of great world economic crisis. So this is the court's decision. The court sided with the government and arguing that the ban did not breach Article 11. And the court noted that applicant in fact exercised two of the elements of the freedom of association that have been identified as essential, namely the right for a trade union to seek to persuade the employer to hear what he has to say on behalf of its members, and the right to engage in collective bargaining. And then this is this ideological surplus. The court went on to state that the right to collective bargaining has not been interpreted as including right to collective agreement, nor does the right to strike imply a right to prevail. So in the case of these equal rights, the law, the legal institution has this technical procedure of balancing of the competing rights. We cannot resolve, but we can do some proportionality, some balance. And this is a signifier of neutral arbitration. But then we have this ideological argument of fairness of contest, topos of fair play. Topos is common sense, something which is taken for granted as a true. There is good word in Slovenian. It is something which is samoumevno. Uzima se, ili u srpskom se kaže, in Serbian, uzima se zdravo za gotovo. But this is old aristocratic ideology of fair play. Yeah. It is like a football game. We gave you equal chance. You played the game, you lose. You had your chance. Why are you complaining right now? The court sided with security, and the court affirmed that the ban on secondary action had a legitimate aim of protecting the rights of freedom of others. The court says that secondary action could cause broad disruption within the economy and affect the delivery of services to the public, because this is a railway engineering company. But then it adds, again, ideological supplements. A court says the 1980 Employment Act has been designed to strike a new balance in industrial relations in the interest of the broader economy. The court accepted that the UK government had banned secondary action to rebalance the economy as a part of its social and economic strategy. Now we have some neoliberal topos, which is part of neoliberal economic theory of ideology. And these topos, these ideologies, these fragments of other ideology, presupposes more than it is saying explicitly. It supposes interpretation of the crisis of the 1970s. The crisis of capitalism, according to neoliberalism, in the 70s is caused by excessive workers' demand, which disrupted the market's equilibrium, hence need to rebalance the power of trade unions and employers. It needs to make this game fair, and the power of trade unions was, before this ban, excessive, and it caused the damage. And at the end, the court said that this ban had remained for over 20 years. Now it's more. This was case from 2014. There was a democratic consensus in support of it and an acceptance of the reason for it, which span a broad spectrum of political opinion. So this is topos of public opinion, consensus, political ideology of topos. So what can we conclude against Lefort? That legal form is not neutral in relation to its content. Here the content is political struggle, class struggle, and the power of legal ideology is to reduce class struggle of the working class and transform it into violation of right to free association in order to protect only individual immediate interest. So this legal contradiction, this legal ideology can abstract this social struggle or other problems, contradictions, short circuits or other problems, and can reduce it to its terms and its procedures, its terminology. And he can abstract for the wider context of class struggle and reduce it just to abstract human right and, in this case, immediate interest of members of trade union. In advance, legal ideology enables a class struggle of the working class, which is possible only by working class solidarity across production sectors, across production units. So the class struggle is reduced to a legal interpretation of an impossible dilemma of legal ideology, as we saw. Because there is a clash of equal rights, it calls for a technical procedure of balancing rights, which produce effects of neutrality of legal decision. And then balancing of rights needs supplementation, which is provided by some of topoi of dominant ideologies of other social spheres. And this topoi, this topos, provides a criterion for balancing process. So legal decision present this as a purely legal decision, but it needs some of the topos from the other dominant ideology, from the other social spheres, which are not from economic ideology, from moral, from political ideology, etc. And these topos are a result of class struggle, because in the period after the Second World War, in the period of so-called welfare state, then the court can derive from topos from Keynesian economics and can make balance the other way. So topos are as Voloshinov said, the sign is the terrain of class struggle, same with this ideological topos. So these topoi are ideologems, fragments of dominant ideologies of some kind of their abbreviations. In the case, this is the fragment of neoliberal economic ideology. So by the way of neoliberal ideology, the struggle of capitalist class to fragment the working class is transformed ideologically into rebalancing of the economy. And you see how these ideological mechanisms, how the balance of competing rights slips imperceptibly into rebalancing of economy. So neoliberal economy is buttressing this seemingly neutral technical procedure of balancing the rights. So political class in capitalist society, political class struggle is channeled into the fight to secure favorable background legal conditions, as Knox said. And we can say that fighting class struggle on the terrain of human rights means the working class may draw some victories, but it cannot win the war. Why? Because, as we saw, the legal ideology have this privileged access to wage form. So the class struggle in the legal form cannot transcend, cannot cross this boundary of the wage form, of bargaining for fair wage. It's limits. So we can say that Lefort is right. Human rights really enables the struggle against oppression, but channel it in a wage form of capitalist relational production, that is in a way that does not endanger capitalist relation of production. Now, let's conclude. Intellectuals who want a real questioning of domination must engage in the struggle over the mode, of the framework of staging the struggle. If you're staging the struggle in the form of legal ideology, like intellectuals do it predominantly, then you do not really questioning the domination. You are trying to have some concession inside this domination, so they can start doing it. I mean, they can start changing the framework of staging the struggle by ceasing to give different answers to the same old question, but to pose differently questions themselves. So we're gonna leave this about political practice maybe for debate or for the other time. So thank you. I'm sorry it was too long, but
ja, hvala za izčrpno predavanje. Zdaj mislim, da smo tudi zadovoljili predpise glede jezika, tako da vprašanja, pitanja, questions, izvolite.
Hour and a half is limit in English.
Možda to ne bude eurobirokrati, ne bude toliko neko došli.
Hour and a half is necessary.
Ako se plašite, onda možete i na engleskom dalje.
Ne, okej.
Budete dobili mail od eurobirokrata, zašto niste nastavili na engleskom.
Tražit će mi vizu.
Vprašanje? Ja.
How do we do that?
No, it's just samo intuitivno da kažemo, ali Knox, na primer, ima jedan tekst gde koristi izlaze iz vojnog rečnika, razliku između taktike i strategije. Taktika je short term, dakle, kratkoročni cilj, a strategije dugoročne. I on kaže da radnička klasa je zapravo prinuđena da se bori kroz legalne forme, da se bori za ljudska prava, ali mora to da čini na takav način da vidi borbu za ljudska prava i ono zašto se može izboriti kao sredstvo kojima se stiže do cilja. A cilj je, dakle, transcendiranje kapitalizma i samih legalnih formi. Dakle, poštujete zakon, što kaže ovde Althusser, ali imate fige pozadi, dakle, koristite ga kako bi ga prevazišli. To je zapravo njega ideja, jer ovo što sam govorio o praktičnoj nužnosti ideologije, kao što je robni fetišizam praktična ideološka nužnost robne proizvodnje, kao što je nadnična forma praktična nužnost kapitalističkih proizvodnih odnosa, ili ova pravna forma ljudskih prava. Isto tako su i zaštite ljudska prava je praktična nužnost kada se borite protiv opresije. Ako vas tuče policajac ili vas neko vređa zbog boje kože ili trpite neko nasilje, nećete čekati revoluciju da reši strukturne probleme represivnog državnog aparata ili rasizma koji su naravno vezani za kapitalizam, već ćete ići tražiti zaštitu svojih ljudskih prava. I ideja je zapravo da se, Knoxova, da se ljudska prava koriste, da se koristi ono što je dozvoljeno, kako bi se ostvarili neki preduslovi za korak napred koji ide u prevazilaženju same legalne forme i samog kapitalizma. To znači da borba radničke klase ne sme biti koncentrisana samo na pravnu borbu, samo na parlament i tako dalje, da se ona mora paralelno, dakle, organizovati, da mora voditi rat na više terena. Eto.
Dobro, ali onda ovde dođe pitanje, jer ako su sve ove male pobjede radničke klase u ovih formalnih pravnih oblicima koje su pobjedene u ovom vremenu i dođe i komplet institucionalni, aktivistički aparat sa profesionalcima koji znaju da ove pobjede samo kroz ove uslove, kroz klica na ljudska prava i tako dolaze. Kako je moguće da sve, kad idemo na jednoj strani institucije koje su profesionalno aktivističke i na drugoj strani možda neki pokret koji pobjeđava u ovim malim pobjedima kroz ove male bitke, kako može pobjede koje su subsumirane u buržoaski pravni aparat praviti preduslove stratešku dugoročnu
Pa,
pogled.
evo vidite, to je ovo što sam preskočio, kad sam nije mogao, samo da nađemo. Radnička klasa se nakon Drugog svjetskog rata izborila za protekciju zakona, za toleranciju ovih štrajkova solidarnosti. I to je isto ovo izuzetno interesantno. Naime, uspjela je da obezbedi povoljnu interpretaciju ovog izraza da je štrajk dozvoljen ako je učinjen in contemplation or furtherance of trade dispute. I oni su uspjeli da se izbore preko laborističke partije, koja je tad bila partija Rada, koja je bila laboristička, koja je imala uporište u jakim sindikatima, da se toleriše štrajk solidarnosti. Ali nije postojala ova taktika za dalje prevazilaženje. Tako da je moguće i treba se boriti u ovim institucijama i treba gurati te stvari, ali da se sistem dovede, dakle, pred pucanje, a onda imati plan i strategiju za preuzimanje vlasti i revoluciju. Znači, paralelno sa ovim radom kroz institucije treba praviti revolucionarni pokret i tako dalje.
Da, moje pitanje je bilo kao u sadašnjici imamo ove institucije i profesionalne aktiviste koji imaju za horizont samo ljudska prava. Ovdje ima neka ambivalencija možda ljevičara od ovih organizacija, jer po jednoj strani vidimo da prave u ovoj pad poziciji idu na dobar balans za to za što se možda mi bore ili zauzimamo, ali po drugoj strani vidimo da odmah kad je ova mala pobjeda dostignuta, to je kraj priče. I pitanje je bilo, kad ti baš...
Ne, pa imam banalan odgovor, treba ih edukovati sa marksizmom. Ali i oni su u problemu, to su sve ova prekarijatna zanimanja i njih je sve manje tu šanse za posao, za neki dostojan život. I ja sam imao slučaja da na fakultetu radim upravo sa ljudima koji su iz nevladinih organizacija i koji vide da tu nešto ima, da nije najbolje, i onda kad im date nekakvu teoriju, onda menjaju način razmišljanja i sad to je proces kada će biti u situaciji da menjaju i praksu i tako dalje, ali prosto nemam drugi odgovor, ali prosto, ali...
Ja, jaz mislim, da ta razlika med taktiko in strategijo je blef, je falš. Namreč, politični učinki Lefortove teorije niso odvisni od Lefortove teorije. V času, ko je razvijal v 50. in 60. letih, je bil horizont socialdemokratski razredni kompromis. In je njegova teorija, da pravo omejuje arbitrarnost oblasti, bila socialdemokratska, kar pomeni izboljšave, ne pa izhoda iz kapitalizma, treba vedeti. Ko je v 80-ih prišel kontravdan, razredni kontravdan vladajočega svetovnega kapitalizma, je Lefortova teorija postala liberalna in antisocialistična. Kar pomeni, da ta teorija ni teorija, ampak je ideologija. Ker učinki niso odvisni od njene notranje logike, ampak od konteksta. Zelo dam pa drug primer, ki je aktualen. tik prednji je zgubil Jospin, socialistični vodja v Franciji, je bil predsednik vlade. In tik prednji je kandidiral za predsednika Francije, kjer je zgubil proti Le Penu in Chiracu, ki je potem postal predsednik, z levimi glasovi, socialisti in komunisti in tako dalje. Skratka, takrat je rekel Jospin, Evropa hoče imeti demokratični socializem in res, socialdemokrati so bili v večini evropskih držav Evropske unije na oblasti. In kaj se je iz tega izcimalo? Nič. To, da imamo danes reakcijo na oblasti. In da je trend, kot se je pokazal v Evropskem parlamentu in sestavi komisije, še bolj na desno, zmeraj bolj na desno. In moja teza je tam. Vi znotraj buržoaznega parlamentarizma zelo težko prijete na oblast. Ampak, ko ste enkrat na oblasti, morate narediti prelom. Skratka, razpustiti buržoazno demokracijo. Ker je, to je leninski udar. Pa veste, on legalno, konstituanto, ki je legalna, ignorira in pravi vso oblast Sovjetom, v trenutku, ko so bolševiki imeli možnost, da prevladajo Sovjetom. Dokler so bili pa eseri, se pravi socialni revolucionarji, ki so bili bolj revolucionarni kot bolševiki, in so na kmete računali. Bolj realistična taktika v kmečki državi, kot je bila Rusija. Skratka, takrat, ko so pa prevladali, je pa rekel vso oblast Sovjetom. Skratka, če ne odpravite buržoaznega parlamentarizma, se vam dogaja to, kar se dogaja v Maduru, ali pa kar se dogaja v Boliviji, skratka, dobite pač reakcijo, ki jo podpira mednarodni kapitalizem in ki nas bo prej ali slej sesula. Maduro se pa ne upa narediti tega, ne? On rajko bi fal pri buržoaznih volitvah, kaj ti bi rekel, mi bomo ljudsko demokracijo upeljali, ne?
Da, ali ova Knoxova podjela je upravo Lenjinova, a ne Leforova. Lefor je naravno socijaldemokrata, teoretičar, možemo reći, eurokomunizma, manje više. I to je levi liberalizam, mislim, to je postalo danas ovo što zovemo radikal filozofija, to je nekakav levo-liberalni filozofski radikalizam, koji nije nešto posebno radikalan. To je ono dokle možete vidjeti na nekim evropskim fakultetima što se tiče levice. Znači, tu je granica i to jeste ta ideja da je moguć miran prelazak. Ali Knoxova je upravo ideja kao Lenjinova kad je bila dilema sa ostrovisti, kako se zvali? Odsovisti, kad je bila dilema da li da uđemo u ruski parlament, u Dumu, ali to je buržoaska institucija. I onda su se podelili oko toga, Lenjin je baš rekao, da, treba da uđemo, ali ne treba da zapostavimo rad na terenu. Tome je razlika između Knoxove taktika i strategija, jer on ne kaže da je cilj da dođemo na vlast, pa buržoaskim metodama gradualno idemo u reformizam, dok ne dođemo do komunizma. Od toga nema ništa. Njegovo je pravimo, dakle, dobijemo koliko možemo, dobijemo kroz parlamentarne, kroz pravne borbe, ali znamo limite takve borbe i strategijski gledamo da prevaziđemo upravo parlamentarnu.
Leninova formulacija je, da je parlamentarna delegacija bolševikov v Dumi, je odred proletarijata na sovražnem ozemlju.
Upravo to.
Bomo še kakšno vprašanje? Dame najprej.
Ni v slovenščini. Ni zdaj čist vezano na to, ampak se mi zdi, da je pač mogoče zanimivo to prenesti na primer, se pravi, okoljski boj, podnebne spremembe in v bistvu kako okoljski aktivisti pač mislim, zadnje čase v bistvu vse več sod, ki so odsojene na stran okoljskih aktivistov. Okoljski aktivisti tožijo pa Big Oil, pač velika privatna podjetja. In ne vem, zdi se mi pač zelo, mislim, zanimiv koncept za aplicirati pač na točno ta primer, v bistvu pač, se pravi, nekega podnebnega boja, pač podnebnih sprememb, se pravi, da so vse, mislim, ja, pač, tako, ne znam bolj podrobno vprašati.
Pitanje šta?
Kad imamo ove ekološke
to sam kapiral.
i da imamo u ovo vreme puno nekih odluka suda koje idu na stran ovih ekoloških pokreta, da možemo ovdje uspoređivati, jer se to opet radi na ovoj pravni razini.
Pa, čujte, moguće je, dakle, i da bi opšte pravna forma funkcionisala, potrebne su nekakve koncesije, nekakvi ustupci u ekološkoj tamo, ali sve dok to ne ugrožava kapitalističke proizvodne odnose. Sad, ja ne znam sad toliko oko ekologije, ali konkretno govori se potrebno je više reciklaže, na primjer. Jedan moj prijatelj kojeg sam video posle duže vremena radi u Danskoj kaže da reciklaža nije nikakvo rješenje problema. Reciklirane, recimo, plastike mogu da se prave neke kabanice za jednotrednu upotrebu, ali vi svejedno i prerađujete to, dakle, pravite još više đubreta, ali recimo, ja se sjećam kad sam prvi put video plastičnu bocu Coca-Cola od litar i po, možda je bio kraj 80-ih ili tako nešto. Dakle, bila je sve staklena ambalaža koja se menjala i tako dalje. Zašto se ne zabrani kapitalističkim velikim kompanijama da proizvode u plastičnoj ambalaži koja se odmah baca, na primjer. Tako da sve to ima neke, verovatno nekakva, dokle može da ide, a šta je već ono što ugrožava sam kapitalizam.
Možda samo, kod nas imamo kompaniju mineralne vode koja se bavi zelenom i svašta, ali ima ove staklene boce koje može kružiti, ali voda u staklenim bocama je skuplja nego u plastičnim bocama jer oni trebaju ovu ambalažu onda čistiti, ali plastične boce samo bacaš.
Ja imam možda slično pitanje kao kolega. U obziru ta kontradikcija između slobode i sigurnosti i čak to zadnje što ste rekli, taj tandem strategije i taktike, da. I ovi historički primjeri gdje under the pressure of the labor movement postižu neki pravni. Tendiraju ka nekoj istini da na kraju odluči moć ili sila. Gdje se sretnu dva ista prava, na kraju odluči...
To je Marxova formulacija.
Tako. A na kraju ste na zadnjem slajdu razdelili ste uloge u revolucionarnoj bitki, intelektualcima ste dali neka postavljaju pitanja, a radniki nek štrajkuju. Što je logično jer intelektualci ne mogu da štrajkuju, ali jer na kraju odluči sila da li intelektualci uopšte imaju onda baš neku bitnu ulogu u revolucionarnom pokretu.
Pa mislim...
Izvinite, da li imaju neku nužnu ulogu u revolucionarnom pokretu?
Pa, bez revolucionarne teorije nema revolucionarne prakse. Teorija je uvek korektiv ovoj praksi, jer Altiseri, jel? Spontana praksa je ideološka, nikad nije spontana. Uvek je posredovano nekom ideologijom, a vi tu ideologiju vidite kao nešto što je spontano, prirodno, samoumevno ili tako dalje. Tako da je teorija uvek korektiv. A to što je pravi problem i zašto danas nema rješenja jeste pitanje zapravo prevođenja teorije u političku praksu. Danas imamo odlične teorijske analize marksiste u svim domenima, ali prosto teorijski problemi i konkretni politički problemi su dve razine. I nekako sad treba teoriju pretvoriti da bi bila efektivna u ideologiju i taktiku i strategiju. To je opet sada problem uključenosti u konkretne političke borbe, poznavanje ljudi, ideološke konekture, neke strategije koje su političke, moć kako da znate se ljudima, kako da organizujete, kako manipulišete, a usto da imate teoriju. To je najbolje ako imate teoriju koja kroji praksu i praksu koja menja teoriju, postavlja i nova pitanja i ona obrađuje. To je, nažalost, danas malo razdvojeno. Ali to je ovako pravi problem koji je pred nama.
Mislim, čisto da možeš odgovoriti kolegu, pač pol posarju po branju kapitala, itak sama teorija je praksa. Sama teorija je oblika praksa.
Imaš trajkanje.
Teoretska praksa.
Kaj sem prav podsvega.
Kaj je zdaj v bistvu
Ni štrajkanje, vse.
Kaj je zdaj funkcija v stvarnem boju, pač si jaz to razlagam, je ta, da v bistvu kritizira in napada vladajočo ideologijo na polju delavskega boja in s tem, ker pač kaj so praktični učinki ideologije, so te, da onemogočajo politično organiziranje. In naloga znanosti je, da skozi pač te epistemološke prelome uničuje vladajočo ideologijo, ki tudi pač je prisotna v delavskih gibanjih, v aktivističnih organizacijah in tako naprej. Tako da ni tle nikoli to samo neka ločena znanstvena praksa, ki moramo vprašanje formulirati, kako sploh iskati most med teoretsko prakso in politično prakso, ampak je pač teoretska praksa že inherentno politična vedno.
Pa na koncu prije vedno do vprašanja, kako ugrabiti te topose, o katerih smo govorili. Če se da stvari skomunicirati samo čez te topose, da pridejo do nekega naslovnika, da te ne označijo za radikalca, še sprejmaš, do psihotika, pa tako naprej, pa vse ostalo. Pa vprašanje torej, kako vprašanje neke ideološke, manipulativne strategije.
Da, kako teorija da uhvati topose, kako da manipuliše s njima retorički i tako dalje, da.
To pa je že, na primjer, programatsko.
Hvala, samo jedno kratko pitanje. Knox kojih si citirao i mnogi drugi kao Adams tvore modernu školu pravne forme sad u ZDA i Engleskom. I njihov stav je da radnička prava samo reproduciraju kapitalističke odnose, kao što si ti kratko pomenuo. Da li se slaže s njime da treba radnička prava zato odbaciti i početi s nule?
Ne, pa ne tvrdi Knox. Ja sam Knoxa čitao, nisam tu
Ne, Knox kaže da ne individualno treba odbaciti, ne treba odbaciti kolektivna prava, prava na udruženje, na organiziranje štrajkove i tako dalje. On kaže da treba ojačati ovo pravo, a što se tiče individualnog radnička prava, to može se odbaciti. To je, ja mislim, Knoxov stav.
Nisam to našao u tekstu koji sam čitao. On tu ima ideju baš to da ova dilema nemoguće se rešava, da je i nužno i nemoguće i on onda pravi tu razliku između taktike i strategije i da je baš primer laborističke partije i te jakih sindikata. Ima onu, zaboravio sam to, Gramscijevu podelu, kako radnička klasa od ekonomskog, korporativnog se uzdiže na nivo celokupne klase i onda treba, stigle je bile dotle i treba treći korak koji je revolucionarni, ako, mislim, to je ono što su 20-ih zvali program prelaska u socijalizam. Tako da ovo nisam od Knoxa uhvatio to razlike, da treba baciti individualno, ostaviti kolektivno, nisam.
On kaže samo da ono što treba ojačati je kolektivno pravo, da su sindikati jači, da mogu djelovati ne samo kao korporacije unutar jednog poduzeća, nego
znam što me to pitaš.
Klasna organizacija. To je njegov stav. A što se ostalog tiče, to nije više važno onda. Da će ova organizacija sama po sebi uspjeti pronaći odgovore budućnosti.
Znam što me to pitaš, jer tvoj stav da prvo treba da se izjednače prava u preduzeću, da nema više ovih različitih statusa, različitih ugovora. Da to si htjela?
Ne, nisam htjela, samo sam tvoj stav, jer si čitao Knoxa.
Da, nisam naišao na to. Ne.
Jer možemo isti tekst čitati s ove i ove strane, tako da onda postoji bitna druga pitanja.
Možda se ne sjećam, jer ja sam možda uzeo ono što je meni bilo, a pošto sam ovaj tekst pisao pre pola godine, tako da moguće da...
This will be in English.
Yes, of course.
Sorry.
Yeah.
I don't speak Slovene, so I don't understand the debate, but just want to pose this thought, taking from the presentation. I'm just open to everybody. I wonder in what topos are we today? Because I think this is a historical context, but I don't know what topos are we actually today. We're in a time of war, in a time of where the left doesn't actually exist anymore, and a question of war. You take divergent responses from the whole spectrum of the left, both in the war in Ukraine, and I can say they're the same also in the case of the genocide in Palestine.
Mm-hmm.
We saw this happen in the pandemic. We saw this happen in the pandemic. There was disagreement among the left for the vaccine, to vaccine and not to vaccine.
Mm-hmm.
War in Ukraine. With Ukraine, not Russia is bad, it's imperialist, the same, neutral in the end, neutral. So,
it is the question of theoretical analysis. It's a question of analysis, accumulation of capital on a world scale. But let's take, for example, war in Ukraine. There is some theoretician of international law. They are saying that this basic contradiction of human rights, freedom and security, is displaced, is copied in international sphere. Rights of freedom is right of sovereignty of state. It is a right of self-determination. And you have this security principle. It is the interest of so-called international community. It is security. So if you're trying to resolve Ukrainian crisis to be in legal terms, you can find a reason to support Ukraine because of its rights for sovereignty, self-determination, but Russia can play on the same card. There is a struggle for defense of human rights of Russian minority. Or Russia can play on security card and say, your freedom to join NATO and EU is endangering our freedoms and our security. So we can leave this ideology, that it has some ideological function, but real question is what imperialism is what the accumulation of world-scale capital is today. Does we have collective imperialism of West, or we have multipolar imperialism, and it is not a debate between topos, it is theoretical debate. But again, the question of struggle of ideology is a different question. Yeah? Okay.
So just to add, sorry, I mean, we have some multiple topics here.
Yeah.
So we have a multiple, this argument can conclude into a judgment, syllogism.
Yeah.
So we have to take we'll see one part of the syllogism, our point, but the other point is equally valid. So the place is like playing billiards. Now.
Yeah, but ideology, that is a vicious cycle of ideology. There are different options and they are equally valid.
Are they, that's my question, are they or are they radically other?
Are they?
Are they or are the other topos radically other to ours? And we cannot judge it, we cannot conclude it. I mean, the right of Russia to decide itself
Yeah.
can be non-determinable as we saw before. The right of Russia, sorry, I repeat, the right of Russia, the topos of Russia to defend its territory, even to attack Ukraine, can be maybe non-determinable. Because if we see it from a non-legal positivist view, it's defense. While in the legal positivism, it's a crime. So, we ourselves, inside an imperialist group, over-determined by this group, we are maybe forced, let's say, dominated by a certain discourse, which the other agent is not determined by this discourse. I'm not saying we are played by the discourse, but we are determined, over-determined by our position of power inside this place. It can be employed, it can be students, it can be anything, but the other agent may not have this condition. Restriction may have others, but okay, I'll conclude again. Question for the future: how can these different agents formulate a collective subject, but in terms of otherness? I mean, if we don't create a party of European left, because we saw how European left went through the last year, but we can recreate, I do not know, an idea of proletariat which is not based on a single syllogism, which can define in short terms, defining multipolarity. This is only a formal question. So, many things.
Yeah, but
Sorry.
I don't have an answer.
Yeah, that's.
Well, Professor Močnik calls the party the collective intellectual.
You were speaking about topos. Israeli topos is security. The right of the Israeli state to its security. But it is overdetermined by the colonial past and the fact that it is a settled colony, which means that this topos is grotesque in this case. You don't have the same situation as in Ukraine, where you can make a reasonable argument for Ukrainian or for the regime of Ukraine stance. You can make a reasonable construction. You cannot make a reasonable construction for Netanyahu's position, because it is a purpose of security, but it's overdetermined by the imperialist and colonial situation. So here you have your solution of overdetermination, while in Ukraine case, it's not so clear, at least not to European left. Nothing to say about the right. Yeah. Just not.
Vse po mojem, da na tej točki zaključimo.
Ne, zdaj, ko imaš načelo vprašanje.
Ja, pa.
Samo sam htio pitati kakav je vaš pogled na ove štrajke i solidarnosti, jer recimo da bi bilo to na engleskom legalno, recimo da bi pobjedili, ne znam, 2, 3, 4 štrajke više nego su sad pobjedili, ali još uvijek si zaključan u ove sisteme rata, radničkog boja, iznutra ovih sindikata i kolektivnih pogajanja, etc. Ili je na drugoj strani ovaj štrajk solidarnosti toliko jako orodje za kolektivnu, za radničku kolektivnu zavijest, da je zato tako, ne znam, može biti štedljivo prema kapitalu.
Probat ću se da govorim, pa ti reći da li je to što si pitao. Vrlo je bitan štrajk solidarnosti zato što on povezuje radnike, dakle, iz različitih kompanija, različitih proizvodnih sektora. A uslov za efektivnost radničke borbe da ona ne ostane na nivou jednog preduzeća ili čak i manje od toga, na nivou jedne, da kažemo, veštine, jedne struke ili jednog radnog ugovora i statusa i tako dalje. Zato je vrlo bitno da štrajk solidarnosti obezbeđuje, dakle, to ujedinjenje radnika, ima, dakle, potencijal da dovede do ujedinjenja cele radničke klase i do solidarnosti koja bi dovela, dakle, u pitanje sav kapitalizam. Ovako, kada on ostaje na nivou ovog što zakon neoliberalni tvrdi, da sindikat brani samo neposredne interese svojih članova i da ne ide dalje od tog spora i ovog apstraktnog ljudskog prava, to znači da se klasna borba fragmentira i od klase se pravi jedna interesna grupa, a ne klasa. To si hteo ili?
Da.
Jaz imam še eno pripombo, mogoče bo malo drugačno. Prej smo slišali nekajkrat omenjeno, recimo Coca-Cola, kako poslabšuje onesnaženje, pa naftna podjetja, pa tako. Bi upozoril na eno univerzo v Kaliforniji, v San Franciscu, zbira dokumente ene 5-6 industrij, ene 5-6 panog, kjer se bo dalo nekako sestaviti zgodbo, kako v bistvu uspevajo recimo biti precej škodljivi. V glavnem so take precej škodljive panoge. In manj me zaboli, včasno slišimo nekoga, ki zagovarja kakšno najbolj škodljivo industrijo. Bil sem slučajno na enem simpoziju o debelosti in v projekciji bo, ne vem, čez 10 let bo 2 milijarde predebelih. Ali pa recimo za sladkorno bolezen se ve, da samo narašča po svetu in v Sloveniji in v Srbiji posod. Tako da ni pa, tudi na tem simpoziju nas je bilo več kot 200, noben ni hotel povedati, kaj je rešitev, pa v bistvu jih je veliko vedelo, ampak sploh ni bilo govora o tem, da bi to preprečili. Potem menjeno bilo kajenje, področje, ki se kar ukvarjam z njim. In recimo v Veliki Britaniji je bilo tako, ena rešitev problema kajenja je, da z neko letnico, bi rekel, se neha ta izdelek prodajati, ker je tako zelo škodljiv, temu se reče generacija brez tovaka. In v parlamentu so že glasovali o tem, v House of Commons, o tem sicer noben medij ni poročal, in je bilo 383 glasov za, pa 67 proti. In potem so bile neke izredne nove volitve in je zmagal ta Keir Starmer. In zdaj on je pa neke lažne ukrepe in v bistvu, da nekako se v parkih prepoveduje kajenje, pa ne vem kje še, kar je v bistvu ena popolnoma nepomemben ukrep, ki pa veliko nasprotovanje doživi. In zdaj Evropska komisija, ta še pretekla, oziroma komisarka za zdravje Kirja Kudes, je zdaj to poslala po vse države, da naj sprejmejo prepoved kajenja v parku, kar je totalno brez veze in doživlja veliko nasprotovanje, ne. Hkrati pa niti omembe ni, da bi se z neko letnico nehalo mladim tak škodljiv izdelek prodati. Tako da, pa teh problemov je veliko več, ne, sej, ampak sam 2-3 sem omenil. Mi izgubljamo, dokler ne bo revolucije, ne, dokler delamo ali pa čakamo na revolucijo, ne, vendarle izgubljamo bitko vsakodnevno proti tem, da rekel, korporacijam, ne, zato ker se sploh ne bori noben proti njim, no, to je moje mnenje. Ker nimamo dovolj znanja, ne vede, ne, podpiramo.
Bi se dalo opisati kot tehnike sprenevedanja tistih, ki izhajajo iz pozicije moči.
Te v glavnem ustanove se mi zdijo pa res že zelo ugrabljene, no, tako, vse smo videli, kako se to postavlja, te ljudi in ta Ursula von der Leyen in tako dalje, ne.
Završimo na Tomi.
Idemo na pušenje.